Welcome back to the deep dive. We are jumping right into the timeline today, transporting ourselves to a very specific date, February 18th, 2026.
Yeah, we've got a decision coming out of the Eastern District of New York, handed down by Judge Brian M. Kogan.
The case is Roosevelt Road Re Ltd v. William Schweitzer and Associates. And listen, if you are working in insurance, if you handle claims, or if you're anywhere near legal compliance, you really need to stop what you're doing and pay attention to this one.
It really is a watershed moment. This isn't just some, dry court order about a contract dispute.
No.
This case represents a fundamental clash between the commercial reality of how modern insurance is structured, specifically the reinsurance and fronting markets, and the very strict, very literal requirements of federal racketeering laws.
We are talking about RICO.
We are. And usually when people hear RICO, they think of, I don't know, the Godfather or mob bosses. But in the insurance world, it's often the nuclear option used to try and stop these massive fraud rings.
And before we get into the legal weeds, which we definitely will, we have to set the scene. Because the allegations in this complaint, they read like a movie script.
They really do.
We are not talking about a guy slipping on a banana peel here. We are talking about an industrial-scale operation.
Right. The complaint details a scheme involving a really complex network. You have a law firm allegedly directing people known as runners.
Runners, it just sounds so clandestine.
It is. I mean, these runners were allegedly sent out to recruit construction workers. And not just any workers, they were specifically targeting non-English-speaking workers.
Which is a huge red flag immediately. You target a vulnerable population that might not understand the workers' comp system or their legal rights.
Exactly. It makes them much easier to manipulate.
Yeah.
According to the complaint, the runners coax these workers, the claimants, to stage or exaggerate injuries right there on the construction site.
Like fall off this ladder or claim your back gave out lifting this box, that kind of thing.
Precisely. And once the injury is staged, well, the assembly line starts.
And it moves fast.
Correct. They rush the workers off to specific doctors, referred to in the documents as medical professional defendants, to get immediate and often completely unnecessary treatment.
Okay, so here's the engine of the fraud, right?
This is the economic engine. The complaint alleges that the value of the kickback paid to the organizers increases pro rata with the intensity of the medical treatment.
So the more surgery they perform, the more injections they give, the more money the whole enterprise makes.
That's it. It incentivizes maximum medical intervention regardless of the actual injury. And this creates a paper trail of high damages, which the law firm then uses to file these massive civil suits against construction companies and file workers' comp claims. It's a volume business.
It sounds horrifying. And honestly, it sounds like a slam dunk for a RICO case.
Yep.
You have the enterprise, you have the predicate acts of mail and wire fraud, you have millions of dollars in damages.
It seems that way.
But here's the hook. Despite these incredibly detailed allegations of a massive racketeering ring, the case was dismissed, thrown right out of court.
And that is the mission of this deep dive. We are here to determine if the fraud actually happened, and we'll get to a fascinating update on that later. But the court didn't even get to the fraud part.
Right.
We need to understand why the lawsuit failed. And it comes down to a friction point that I think a lot of our listeners in the reinsurance space might be overlooking. It's about RICO.
And it's pronounced RICO.
It is RICO.
Yeah.
And it's about the critical legal difference between who pays the bill and who actually owns the claim.
Okay, let's unpack this, because the reason this case failed has nothing to do with whether the fraud actually happened and everything to do with who filed the lawsuit.
Exactly.
So let's look at the players. Who is trying to sue whom here?
On the plaintiffs' side, the ones trying to, bring the hammer down, we have Roosevelt Road Re Ltd.
Yeah.
They are a Bermudian reinsurer. And along with them is Tradesman Program Managers, which is a New York-based managing general agency, or MGA, that services Roosevelt. They are the ones who ultimately felt the financial pain of this alleged fraud ring.
And on the defense side, we have the law firm, William Schweitzer and Associates, and a bunch of others who allegedly orchestrated all these fake injury claims. So naturally, Roosevelt Road is saying, look, your fraud cost us millions in payouts. We are suing you under the Racketeer Influenced and Corrupt Organizations Act to get our money back.
It seems logical, right? But this is where we hit the concrete wall of RICO standing.
Okay.
To sue under RICO, it is not enough to just say you lost money because of a crime.
Yeah.
The law is very, very specific. It requires a direct relationship between the injury and the fraud.
This is that distinction between but for causation and proximate cause, isn't it? I feel like that's a law school flashback for some of our listeners.
It is, but it's so vital to understand the business implications here.
Yeah.
You can argue, but for the fraud, I wouldn't have lost money. And, well, that's true.
Sure.
But RICO demands more. It demands proximate cause. The injury has to be the direct result of the fraud, not a ripple effect, 3 steps down the line. And this is where being a reinsurer becomes a fatal flaw in the eyes of the court.
Because they're a step removed.
Definitionally, a reinsurer is removed from the event. The fraud hits the primary insurer first. The reinsurer just reimburses them.
I think we need an analogy to make this stick, because in the real world, if I lose money, I feel like I should be able to sue the person who caused it.
It feels that way, but the law treats these remote injuries differently. Think of it this way. Imagine you run a taxi company.
Okay, I'm running a fleet of cabs.
And a reckless driver crashes into one of your cabs. That's the fraud or the tort. You, the taxi company, you can sue the reckless driver because your car's smashed. That is a direct injury.
I'm with you. My property is damaged. I'm out of cab.
Now imagine a bank that lent money to your taxi company. Because your cab is smashed, you can't make money from fares, and you default on your loan to the bank.
Ah, I see where this is going.
The bank has definitely lost money because of that crash. But for the crash, the bank would have been paid.
But the bank can't sue the bad driver who hit my cab.
Exactly. They are too far removed. The driver hurt the taxi company. The taxi company's financial trouble hurt the bank. It's indirect.
So in our case, the taxi company is the primary insurer.
Yes, a company called Accredited Casualty and Surety Company. They issued the policy. They're directly liable to the insured. Roosevelt Road, the Bermudian reinsurer, is the bank. They have a contract with Accredited to reimburse them.
So when the fraud happens, Accredited pays the claim, and then Roosevelt reimburses Accredited. The fraud technically happened to Accredited.
That's the entire ballgame. You have to distinguish between liability and indemnity. Accredited, the primary carrier, is unconditionally responsible for payment. They are directly liable. Reinsurance, on the other hand, involves contracts of indemnity. They don't technically examine risks or investigate claims in the eyes of the law. They just pay the bill for the primary carrier.
There's a court precedent on this, right?
There is. The Second Circuit precedent in Unigard puts it very plainly. The reinsurer has no contact with the insured.
Okay, here's where I get a bit confused, though. Roosevelt Road isn't stupid. They are sophisticated players. They had to know this was a potential issue.
They did.
And they tried to argue their way around it. They admitted they aren't licensed in New York, which is why they used Accredited as a fronting carrier in the first place.
Right. Under New York insurance law, section 1102A, you can't be an insurance provider if you aren't licensed. So Roosevelt uses Accredited to put their name on the paper, the front.
But Roosevelt's argument was, look, Judge, that's just on paper. In reality, we, Roosevelt and our MGA tradesmen, we did all the heavy lifting. We administered the claims, we posted the reserves, we defended the claims, we paid the expenses. Accredited did nothing but lend their signature.
They basically argued they stepped into the shoes of the primary insurer. It's a very common commercial argument. They call it the functional equivalent test.
It makes sense to me. You know, if it walks like a duck and quacks like a duck, they were saying, let me sue the fox that's eating the ducks.
Logically, it makes perfect sense. If I'm doing the work and paying the money, I should be the one holding the sword.
But Judge Kogan didn't buy it.
Not for a second. And this is the teaching moment for anyone using a fronting model. The ruling emphasized that even if Roosevelt did all the legwork, Accredited was the one legally on the hook.
Ah.
The order states, and this is a quote, Accredited, is unconditionally responsible for payment of the claims. That one fact reinforces Roosevelt's true status as a reinsurer. Their injury is derivative. It just is.
So it comes down to who the policyholder looks to for payment. If Accredited goes bust, the policyholder still gets paid. But if Roosevelt goes bust,
Accredited still has to pay the policyholder. That legal barrier, the corporate veil of the primary carrier, cannot be pierced just because a reinsurer does the admin work.
So the judge is essentially saying, you chose this structure. You chose to use a fronting carrier because you aren't licensed. You can't have the benefits of the structure like regulatory access without the burdens like lack of standing.
That's it, exactly. No matter how much sweat equity Roosevelt put into managing these claims, legally, they are still just the bank waiting to be reimbursed.
And that explains why this case was dismissed so quickly. It wasn't just analyzing these facts from scratch. It was about, what was it, collateral estoppel.
Correct. Collateral estoppel, which is just a fancy way of saying, stop wasting my time. We have already talked about this.
Right.
Essentially, yes. This case, Roosevelt v. Schweitzer, isn't the first time Roosevelt Road has tried this argument. The judge references a prior case, Roosevelt Road Re Ltd v. Subin, which is referred to as Subinai.
Okay, so what happened in Subinai? The same thing.
Pretty much the same setup. Roosevelt sued a different law firm under RICO for a virtually identical scheme. And in that case, the court ruled they lacked RICO standing specifically because they are a reinsurer.
So they lost Subinai. Did they just copy and paste the lawsuit for this new case and hope for a different judge, a different result?
Well, they tried to pivot. In the previous litigation, after they lost on the standing issue, they tried to amend their complaint. They changed the language to say they were substituting for accredited or acting as a primary carrier. They tried to reframe themselves.
They tried to change the label on the jar.
Exactly. And the court, in Suite II, the follow-up, shut that down too. The court ruled that you can't just change your legal theory if the underlying commercial relationship hasn't changed. The judge called it creative repackaging.
So when they got to this case, the Schweitzer case, the judge looked at it and said, hold on, we have already decided this exact issue.
Yes. For collateral estoppel to apply meaning, to bar someone from re-arguing a point, you need 4 things. The issue must be identical. It must have been actually litigated and decided. The party must have had a full and fair opportunity to litigate it, and it must be necessary to the judgment.
And Judge Kogan just ticked off all 4 boxes.
One by one. The full and fair opportunity part is interesting. Roosevelt tried to argue, hey, we never got to fully argue this stepping into the shoes theory in the first case because you dismissed us.
That was a Hail Mary pass.
It was. But the court points out that they did have the opportunity. They litigated the standing issue extensively in Subin I. Just because they chose not to lead with that argument back then, or because they failed to convince the court to let them amend the complaint later, doesn't mean they get a do-over now with a new defendant.
The underlying fact that they are a reinsurer indemnifying a fronting carrier, that hasn't changed.
Exactly. You cannot plead your way out of your own corporate structure. If you're a reinsurer in the contract, you're a reinsurer in the courtroom. Period.
So the case is dead. It's dismissed. Now, I want to clarify something really important, because this is where listeners might get cynical. Does the fact that the case was dismissed mean the fraud didn't happen?
No. That is vital to understand. The decision on standing does not mean the fraud claims are irrelevant or untrue. The court isn't saying William Schweitzer and Associates is innocent.
It's just saying Roosevelt Road is the wrong person to be pointing the finger.
The wrong party to file the suit. It's like if I saw someone rob your house, I can't sue the robber for the value of your TV. The robbery happened, the TV is gone, but I don't have standing. You do.
And the you, in this case, is accredited.
Precisely. Only the primary insurer accredited would have the direct standing to sue under RICO here.
Now, here is where it gets really interesting and, frankly, a little suspicious. While the court didn't rule on the fraud, actions can sometimes speak louder than words. We have some information about the law firm in question, right?
We do. And this is public record, though it wasn't part of the judge's decision on standing. After the allegations of this fraud scheme came to light, and while these legal battles were swirling, the firm withdrew from nearly 300 cases.
300 cases. That is a lot.
It's massive. They cited suspected fraud as the reason for withdrawal in many of those instances. And eventually, the firm dissolved entirely.
Wow. So even though Roosevelt Road lost the lawsuit on a technicality, the pressure seems to have broken the enterprise anyway.
It certainly looks that way. Now, to be clear, withdrawing from cases and dissolving a firm is not a legal admission of guilt regarding the ISE charges.
Of course not.
But it does raise serious questions. I mean, if there was no fire, why did everyone run for the exits?
It feels like a moral victory, even if it wasn't a legal one. But let's go back to the legal side, because there was one more bomb dropped in this decision. You pointed this out to me earlier, footnote 3.
Ah, footnote 3, the illegal contracts sidebar. This is a real can of worms.
This feels like a ticking time bomb for anyone using a fronting model.
It absolutely is. While the judge dismissed the case on standing, he took a moment to look at the fronting arrangement itself. Remember, Roosevelt argued they did all the work and accredited was just a front.
Right, that was their main argument for why they should have been allowed to sue. We do the work, so let us sue.
Well, the court noted that New York insurance law prohibits aiding an unauthorized insurer. If accredited is just lending its name, so Roosevelt, an unauthorized, unlicensed Bermudian company, can do insurance business in New York, that might be an illegal contract.
Oof. So their main argument backfired spectacularly.
Big time. The court cited precedents saying, quote, "Courts of justice will not assist a person who has participated in a transaction forbidden by statute."
That sounds like the judge is saying, not only do you not have standing, but the very contract you are basing your entire argument on might be void because it's breaking insurance laws?
He didn't rule on it definitively because he didn't need to. The standing issue was enough to dismiss the case. But he explicitly said the court questions the legality of the fronting arrangement. That is a massive red flag for the industry.
So if you're in a fronting arrangement where the fronting carrier cedes 100% of the control and risk to the reinsurer, you might be stepping into illegal territory in New York.
That's the warning shot. It signals that these pass-through arrangements where the license carrier is just a signature on a page are being scrutinized. The courts are onto it.
So let's bring this home. What is the takeaway here? If I'm a reinsurer listening to this or someone working at an MGA, what do I do tomorrow?
The takeaway is clear. If you are a reinsurer, you cannot easily jump the line and sue for fraud committed against the policy, even if you are the one ultimately paying the bill.
That corporate veil is strong.
It is. The corporate veil of the primary carrier blocks you from RICO's standing. You are distinct entities.
Yeah.
And clearly, you can't just plead your way out of it by saying, we did all the work.
No. Creative pleading cannot overcome structural commercial realities.
So if you want to pursue fraud, you need the primary carrier, the one with the license, the one on the policy, to be the plaintiff.
Which brings up a logistical nightmare, doesn't it? If the primary carrier is just a front, they might not want to spend the money on legal fees to sue. They don't have skin in the game.
Exactly. They're getting paid a fee to let you use their paper. Why would they spend millions on a RITO suit?
That is the friction point.
It is. Reinsurers need to ensure their contracts with fronting carriers compel the fronting carrier to litigate fraud. Or they need to ensure the primary carrier has enough retained risk, meaning they actually pay some of the claims, so that they want to litigate fraud. Otherwise, the reinsurer is just a sitting duck.
And that leads us to our provocative closing thought. We have described this alleged fraud ring involving runners, doctors, lawyers, all operating with what seems like impunity. The reinsurer Roosevelt wants to stop them, but can't sue because of standing.
Right.
The fronting carrier accredited technically has standing, but arguably has no incentive to sue because they are just a pass-through entity getting reimbursed.
So it raises the uncomfortable question, who is left to stop the fraud?
Exactly. Does this specific insurance structure, this fronting model, accidentally create a safe haven for racketeering? If the only person who can sue doesn't care, and the only person who cares can't sue, the door is left wide open.
And until the industry or the regulators address that gap, or until fronting carriers start taking the lead in these lawsuits, we are likely to see these schemes continue. The dissolution of one firm doesn't stop the model from being replicated elsewhere.
A sobering thought to end on. That wraps up our deep dive into Roosevelt Road Re Ltd v. William Schweitzer, a case about who gets to fight back and why RICO standing is harder to get than you think. Thanks for listening, and we'll catch you on the next deep dive.